Honorable High Court after the merger. In the meantime, there is judgment delivered by this court holding that in spite of merger, the contempt would lie before the Honorable High Court. That's the judgment I would rely on.
Now the High Court is seized of the
counsel in
whatever.
That's my prayer, that the contempt should also come.
Why don't you, the writ petitions, whatever is pending, you file an intervention application or file a fresh writ petition?
This is the contempt.
We've already said in the other orders that if any tainted candidate...
No, this is not that. This is not that.
We don't know what the violation is because there's
a violation because of the several directions of the High Court which was upheld by your Lordship. We had filed the contempt there. The Honourable Court felt that since this is a merger, then the contempt should be filed before the Honourable Supreme.
What does this bench say now? KUMAR is considered?
Yes, they have considered and said no, in spite of merger, the contempt will lie before the High Court.
Only if there is no fresh directions. Only if there is no fresh directions. There are fresh directions in our case.
If the contempt is heard by the High Court, they will have the difference there.
No, but para 13.
Yes.
And if the Supreme Court has not issued any fresh directions in the matter, merely affirm the order passed by the High Court, then of course. Yes. But here we've given fresh directions.
No, what would remain to be executed is the...
In any event, the High Court is seized of the matter, you go before the High Court.
Yes, this is what I was asking for.
Not by way of a contempt.
Yes. But
by way of a contempt.
Otherwise there is the compliance of the order of the court.
No, if you are saying that any particular candidate or
No.
What is the violation that you allege?
The court directed below that the OMR should be published. They have not. Within 4 weeks.
So that is also a fresh cause of action. Then you also said that.
By the
for 1 minute.
Yes.
And she has said with a tainted candidate herself. This petition is a tainted candidate.
Direction of the High Court cannot follow that all.
Kindly see below minus deduction at page 313.
What is it that you want to get out of the OMR sheets if you are already classified as a tainted?
I am not at all tainted. I am the petitioners who have succeeded up to High Court, Supreme Court. Now your Lordship was pleased to give
you are not a tainted.
She is one of
them. The directions are kindly see the appointments granted in the selection process are quashed. OMR sheets available in the 3 hard disks. If not already done.
I don't know how to pronounce it. Mr. Sibal might be better placed in pronouncing it. SCIREFACIAS.
Well, I won't even attempt.
That is, when you ask for a writ of whatever, CREFACIAS or whatever it is asking for another writ to enforce an earlier writ.
Correct.
So that rate you can still ask for.
No, violation of the order of the Supreme Court, Lord, is the contempt. Deliberate violation.
You don't need to ask for a contempt. You can ask for an enforcement, which is basically what you want. Is it not?
Yes.
You want to call it a contempt, or do you want to find result?
Enforcement by a contempt, but the enforcement has to be done by High Court.
Enforcement by way of a writ.
Yes. Again, our further writ. Well, this is a contempt petition. The contempt
we can find no error having been committed by the High Court in refusing to entertain a contempt petition in the light of the fact that the order passed by the High Court is deemed to have merged with the later order passed by this court in the light of the law laid down by this court in KUMAR versus State of Kerala, 2000, Volume 6, SSC 359. We may also note that this court had passed further directions in addition to what had been stated by the High Court, and therefore the edict of this court in United Labour Federation versus Gagandeep Singh Bedi, 2026, SCC online, Supreme Court 331, would not apply.
So they would have a contempt before this court also.
You would not find this as a contempt though.
No, we have also find the contempt.
This is an SLP.
That was the SLP. That was the SLP from the High Court's order. Now we have independent contempt for Lordship.
Where is it?
51.2.
1.2.
2 and 3.
1.2. Very well. This 51 and 51.1 will go. We'll see 51.2.
Can you see
51.51
now
51.1. How However, the mere fact that contempt proceedings would not lie before the High Court in the light of the aforestated position would not mean that the petitioners cannot approach the High Court to seek enforcement of the directions passed earlier by the High Court, which were left intact by this court while passing the final order, leaving it open to the petitioners to do so, the special leave petitioners. To do so, the special leave petitions are disposed of. We, however, make it clear that all issues will be open for consideration before the High Court, including the locus of the petitioners invoking its jurisdiction, as well as the maintainability of the proceeding instituted by them.
The next matter is
51.2 and 51.3. This is the file.
No notice, no certain.
No, I think this matter also can be please to issue notice so that
No notice has been served on us.
It was tagged, whether it was tagged.
There is no notice. No notice.
Notice was issued in the
No.
what she was pleased to tag it up with that matter.
That's all.
That
No.
matter
only tagged with.
Yes.
What is that one?
Not.
What is the violation that you are mentioning?
Can you come to the page 336?
It's all right. It's
Like, these are the special directions of the Honorable Supreme Court. No, same directions which has been upheld by the Supreme Court. Kindly come to the Roman 3 and follow.
6, 5 and 6.
Have you not uploaded these OMR?
No.
You are appearing for the board also.
I am appearing for the commission. Lordship, the names and details are all.
You would be appearing for the state bank.
Yes, I am preparing for the state.
Names and details are all uploaded. Lordship knows that.
OMR sheet.
OMR sheets,
Absolutely
we
destroyed.
need certain, because of the ongoing recruitment, it's a heavy data.
How is the
OMR requires a different kind of tendering process and all. We will do it. We have said in our evidence.
This was to be
Why
done.
are you linking it with the latest election?
Because our server is one. Oh, server space will get.
But you had it in 3 hard disks.
It is there. We have given in our affidavit in the other matter that we do it. We will do it. There is nothing. We have.
Why have you not done it till
We have
now?
uploaded all the data without the WMR because that is a
Have you
PDF.
at least applied to the High Court for extension of time to do this?
Nothing.
You take it for granted.
We have
High Court says forthwith.
Yes.
forthwith.
Forthwith has also been dealt with by this court. There's a judgment on the scope of forthwith.
Lordship,
As soon as can be is what it
we
says.
have said in our affidavit.
So as soon as can be doesn't mean that you will complete the next selection
we have
and thereafter upload
Lordship,
the.
we have uploaded all data.
Nothing.
Only
There
the
is a specific direction
Now that
saying
that-
OMR sheets available in the 3 hard disks.
You remove
If
the High
not
Court, then
already done,
Not
or such
Lordship,
court
Lordship, my
not
project is
done.
to move to the High Court for making a suitable prayer for this extension because Lordship was hearing the other.
What is the other violation?
Then the kindly come to 4, Roman 4. The direction was who have been appointed outside the panel after expiry of the panel, also those who submitted blank framer sheets but obtained appointments must return all remunerations and benefits received by them to the state exchequer.
that is on, Manoj. That
Nothing else saying.
That process is on.
that process.
Kapila, this is wrong.
We have written to all the collectors.
But only writing a letter before filing the application is not compliance.
Always
That
period
process
is there.
is wrong.
The
Then we'll issue notice on
Yes,
this.
yes.
File your count.
Yes, we
Kindly
will.
issue.
51.2 and 51.3 issue
the
notice
person.
to the respondents
So for the violation of the
committed all by almost simple interest.
Yes. Right.
But in the meanwhile, Milord, what Mr. Chatterjee said, he will be uploading, Milord. So let him upload at least. Because it can't be very heavy because they are all vacant, all blind
These
OMR.
contempt cases will not preclude the respondents from carrying out the directions passed by the High Court oblique this court.
That is, may permit us to move to the High because
You move.
Why do you need our liberty
You
to
move the High Court. Who stops you?
because after your Lordship's observation,
contempt is obvious.
Lord, we will not file a rejoinder, Milord. Let them file a counter with your Lordship. We will not file a rejoinder.
list on. File a rejoinder while
Lord, otherwise, say we'll file additional documents after that.
This blatant violation without with all impunity should not
Then,
Your Lordship may say, we give us liberty to move the High Court for appropriate directions in the matter, Manoj, so that this order may not preclude us, that's all. This order
We
we not
said comply with the direction.
Yes.
Yes.
So once we said comply with the directions, implicit in that is you have to comply.
comply.
No, I agree. But if
The
there is some,
possibility of you
there is some
asking for time.
operational, if there's some operational, it's only in that context.
Not
Anyway,
necessarily.
we can tell this
I put
about
on
the
those
operational
That
difficulty.
4 months will not have already cost money.
No, I think 10th May happens to be a Sunday, you know.
Oh, I see.
If the state wishes to come, Lord,
I see, yes, you're right, 11th May.
11.
Great clear.
Then you get both the day.
Great clear.
So listen, 52 on the 20th March, they filed the counter affidavit by respondent 1 and 2.